Good morning, everyone. Welcome to this panel on the future of pipeline approvals at FERC. If you haven't seen me already, my name is Amanda McKay. I'm the program manager for the Pipeline Safety Trust. I'm excited to welcome all of our panelists, and I think we're going to have a really interesting and informative discussion today. We wanted to discuss this topic because there's been a lot of shift and activity in pipeline approvals at the Federal Energy Regulatory Commission, and much more focus on how FERC grants these pipeline approvals. I'm going to go into a brief history of the process, the statutory authority that FERC has for granting pipeline approvals, and then we will invite the panelists to have a discussion on some of the more recent shifts that we have been seeing. I am no expert in this subject, so feel free to correct me later on if I misspeak on anything. So Section 7 of the Natural Gas Act gives FERC the authority to determine whether a proposed natural gas project is or will be required by the public convenience and necessity. This essentially means that the Commission is looking for whether or not a project will benefit the public at large through either expanded service or lower costs, as well as if there is a market demand for the project. This market demand has historically been determined by precedent contracts. In the context of this session, it's also important to note that FERC has a very high approval rate for pipeline projects. In 2020, the House Committee on Oversight and Reform investigated the FERC approval process for natural gas pipelines, and according to data submitted to the committee, in the past 20 years, FERC has granted 1,021 certificates while rejecting only 6, a greater than 99% approval rate. In 1999, FERC updated its policy for evaluating and certificating new pipeline construction in order to meet the growing demand for natural gas while still considering the potential effect on existing pipelines and the potential for a capacity turnback. FERC was attempting to strike a proper balance between the enhancement of competitive alternatives and the possibility of overbuilding. Through that policy update process, FERC asked commenters to consider whether the Commission should look behind precedent contracts and whether they should apply different standards to agreements with affiliates versus agreements with non-affiliates. In FERC's previous policy, a new pipeline project had to show market support through contractual commitments for at least 25% of the capacity of the project. In the updated policy, FERC eliminated this requirement in the hopes that it would also reduce the significance of whether the contracts are with affiliated or non-affiliated shippers. The Commission is now focused on whether the public benefits that would be achieved by the project are proportional to the project's adverse impacts. Of course, there's much more detail and nuance in the actual policy statements themselves, but this provides a primer for the discussion that we are going to have today. Today, we will dive into the Spire STL pipeline project, the new draft policy statements announced by FERC in February of this year, and the political and legal implications of this rapidly changing landscape at FERC. So now I'd like to let the panelists introduce themselves, give a brief background, and a little bit of an overview on how you specifically work with pipeline approvals and issues at FERC. So Erin, do you want to go first?
Sure. Thanks, Amanda. Hi, everyone. I'm Erin Murphy. I'm a senior attorney with Environmental Defense Fund on our Energy Markets and Utility Regulation team. My involvement in this area of pipeline law really stems from my work on the Spire STL pipeline approval. EDF engaged in that proceeding before FERC. We also engaged in that proceeding, the initial phase of that proceeding that was at the Missouri Public Utility Commission around the contract for capacity on the Spire STL pipeline with Spire, Missouri. And after challenging that certificate application administratively before FERC, we filed a petition for review at the U.S. Court of Appeals for the D.C. Circuit, seeking review of FERC's approval of the pipeline. And I'm sure we'll get into more detail about sort of the course of that litigation. I will also make an effort to speak a bit to sort of the state of play currently at FERC, though we'll note that a colleague of mine is the true expert there. And so I'm going to fill in from some notes, which is why I have my laptop open. But yeah, looking forward to the discussion.
Thanks, Erin. Chris?
Hey, good morning, everyone. My name is Chris Smith. I'm a regulatory attorney with the Interstate Natural Gas Association of America, or INGAA. For those of you who are expecting to see Joan Dreskin of INGAA this morning, she is unfortunately unable to make it today. She is sorry, and I am sorry that you have to deal with her understudy. But INGAA is the trade association representing interstate natural gas pipelines in America. So our member companies, there are 26 of them, are the companies applying for certificates from FERC to construct, operate, or modify natural gas facilities that transport gas across state lines. INGAA does not typically get involved in member application proceedings, so when a company applies for a certificate. However, we will intervene and participate in proceedings that we think might have industry-wide ramifications. So over the last few years, FERC has been having an ongoing proceeding looking into whether and how to modify its 1999 certificate policy statement, which is basically a guidance document saying how it's going to evaluate certificate applications. I will spare you all from having to read several hundred pages of comments. The takeaway is that INGAA as an organization thinks that the 99 policy statement has created a consistent, durable, reasonable, appropriate framework for evaluating natural gas applications, and it really has been beneficial to the country. You know, it's allowed for access to lower cost sources of energy. It's allowed for emissions reductions by enabling shifts from coal and fuel oil to natural gas. It's helped maintain electric grid reliability, while a greater number of intermittent renewable resources are integrated into the grid. And so, as a matter of sound policy, we don't think there should be major changes to it. We also don't think there are really any court mandates saying that you have to make sweeping changes to this policy statement. And I just want to say the 99% statistic sometimes has been used to say that there's a rubber stamp process at FERC, and that's one of the reasons we should change it. And I just want to address that by saying it's a little misleading. FERC staff actually has an extensive pre-filing process in which they do a very thorough examination working with both the applicant and other stakeholders to identify whether the project is needed and some of the other aspects of the project. And so looking at the applications versus approvals isn't necessarily going to be the best barometer, because a lot of the weaker or unnecessary projects are actually filtered out through that searching review. I'm looking forward to the conversation. Really appreciate the opportunity to talk to you today.
Awesome. Thanks, Chris. And Morgan, do you want to take yourself off mute and introduce yourself?
Hi, everyone. I'm Morgan Johnson. I'm a staff attorney for the Natural Resources Defense Council and our Sustainable FERC Project initiative. We advocate for more open, transparent, reasoned reviews of FERC-regulated gas projects that are fully compliant with the legal and regulatory framework around the Natural Gas Act. The Sustainable FERC Project and NRDC have led, multi-year effort of public interest organizations calling for, rebalance of the rubber stamp approval process. That I know the term was coming, Chris. You knew it.
Absolutely. That's why I brought it up.
Yep. So, we have been, engaged in that process of proceedings related to it in past years. And I think that's sufficient introduction for me. Let's get into it.
Thanks, Morgan. All right, so I want to, just jump into it. If you haven't heard about the Spire decision, you are about to. So I'm going to give both Erin and Chris a chance to sort of explain the Spire decision from two different perspectives. Erin, do you want to take it away?
Sure. Thanks, Amanda. I'll start before getting to the decision with a little bit of the background of how we got to that decision, right? Which is the petition for review that EDF filed at the DC Circuit. So the Spire STL pipeline is a 65-mile pipeline. It's an interstate gas transmission pipeline in Illinois and Missouri, and it was intended to bring gas supply into the St. Louis region, which is served by the local gas distribution utility Spire, Missouri. Spire, Missouri, the gas utility, is owned by the parent company Spire Inc., and Spire STL, the company that sought to develop and did develop and construct and now operates the Spire STL pipeline, is also a subsidiary of Spire Inc. So when this pipeline was first proposed and the certificate for public convenience and necessity application was filed before FERC, that application was filed by Spire STL, and the demonstration that was included in that application to support market need for the project was a single precedent agreement between Spire STL and Spire, Missouri. And that precedent agreement, in many ways, I think is the crux of the issue in the Spire STL matter, and was really a source of a lot of concern for EDF. From our perspective, the use of precedent agreements as a way to determine market need is something that has become concerning over time, as FERC in many instances did not look behind those precedent agreements to really assess and seek to determine if they were a true representation of market need. A precedent agreement is a contract between a pipeline developer and then an entity that's interested in securing capacity on that pipeline. So it's something that's often used, it's typically used in proceedings where a developer is seeking a certificate from FERC to operate that pipeline. Thank you for your question. Please chime in at any time if I'm using unfamiliar terms. So from our perspective, that reliance on precedent agreements without looking behind those agreements and really deploying careful analysis to determine whether they are a representation of market need is something that's concerning. And then the Spire STL certificate application was particularly concerning because it was a single precedent agreement being used to justify a new interstate gas transmission pipeline. And that single precedent agreement was between two affiliated companies. And this dynamic is particularly concerning when the affiliate company that's looking to secure capacity on a proposed pipeline is a local gas utility. And the reason that's concerning is because a gas utility can pass these costs on to its ratepayers. And those ratepayers are everyday people who are paying to have gas delivered to their homes. It's also, business entities that are having gas delivered to commercial buildings as well as industrial users. But those customers can essentially be locked in to paying for the costs of a gas pipeline capacity agreement if this sort of specific dynamic is in play, right? Where you have this precedent agreement and the pipeline developer is affiliated with the gas utility. So we see that as sort of an incentive concern where there may not be that same sort of genuine market need in the instance where it can potentially be shifting profit over to the shareholders of the pipeline developer and costs onto the ratepayers of the local gas utility. And because that, instance was at play in the Spire STL pipeline, and FERC in the certificate approval process and decision did not really carefully look behind that single precedent agreement. We viewed that as concerning and really demonstrative of an inadequate review process that resulted in the approval of the pipeline. And getting to the court case and the decision at the DC Circuit, EDF sought judicial review of FERC's approval of the pipeline and then FERC's subsequent denial of EDF's request for rehearing. And the DC Circuit in June of 2021 issued its decision. It was a unanimous panel decision, which is 3 judges on the DC Circuit typically serve on a panel, issued a unanimous panel decision essentially agreeing with EDF's arguments and vacating the certificate that FERC had issued approving the Spire STL pipeline and remanding the matter back to FERC to sort of determine what comes next. And there's a lot of reasons that determining what comes next gets very complicated, in particular because the pipeline was fully constructed and became operational. In fact, FERC approved the pipeline to go into operation about 1 or 2 weeks before they issued their decision denying EDF's request for rehearing, essentially ensuring that the pipeline was completely in operation before EDF ever had an opportunity to really seek a day in court. And I should say not just EDF, but any stakeholder who potentially wants to challenge an infrastructure project like this. That dynamic has shifted in light of some other court decisions and updates to FERC's rules to ensure that there is a really fulsome process and an opportunity to seek judicial review before a pipeline is necessarily, fully built and goes into operation. And sorry, I'm kind of jumping around a little bit, but to circle back to the court decision itself, I want to read an excerpt from the decision. So the DC Circuit wrote that nothing in the certificate policy statement suggests that a precedent agreement is conclusive proof of need in a situation in which there is no new load demand, no commission finding that a new pipeline would reduce costs, only a single precedent agreement in which the pipeline and shipper are corporate affiliates. The affiliate precedent agreement was entered into privately after no shipper subscribed during an open season, and the agreement is not for the full capacity of the pipeline. And I'm sure Chris is going to talk about this, and I don't disagree. That is a unique set of facts, right? That is a uniquely concerning set of facts. But I think, it does speak to broader issues in terms of the way pipelines are reviewed and approved at FERC, because each of those sort of instances, right, are things that require close attention by a regulator and really fulsome review before we move forward with these significant infrastructure projects. I think I've probably talked enough for now, so I'll stop there in terms of I hope that's a helpful overview of the case and the DC Circuit decision.
Yeah, thank you, Erin. That was good background. Chris, do you want to talk a little bit how INGAA was involved in that process?
Yeah, certainly. So this actually predates my time at INGAA, but Spire STL, the company who owns and operates the interstate pipeline that Erin mentioned, is one of our members. And so INGAA participated as an intervener at the DC Circuit level, so at the court level, intervening to defend the certificate. In particular, in subsequent proceedings, the vacatur of the certificate, so the idea that it would be the court struck it down. FERC issued a temporary emergency certificate to Spire, finding that there was continued need for it going forward after the decision. So from our perspective, and Erin hinted at this is actually a pretty narrow or limited decision. We don't actually think it hints at a larger systemic issue. And to see why, I think it's important to take a step back and look at what the court said and what the court didn't say. The court, DC Circuit Court of Appeals, did not say there was no need for the Spire pipeline. The court did not say that FERC's method for determining need as a whole, in general, was inappropriate. It looked at the specific set of circumstances, and Erin read the excerpt there. There were 5 circumstances that it focused on, and it said in light of those 5 circumstances, single precedent agreement with affiliate was entered into privately after no one subscribed during an open season. The agreement's not for the full capacity of the pipeline. All parties agreed there was no projected demand increase in the St. Louis area, and FERC did not make a finding that the pipeline would result in cost savings. In those 5 circumstances, FERC had a responsibility to respond to the arguments that EDF raised about plausible evidence of self-dealing. This case was under the Administrative Procedure Act, the APA, which I think of as sort of the high school math show your work statute. Much to my chagrin, when I was a student, I couldn't just write down the right answer on my math homework. I actually had to show how I got there because the teacher wanted to make sure I understood the lesson they were trying to impart. This is very much similar. So the APA says you need to explain, agency, you need to explain your decision-making so the court can verify that you are following the instructions and guidance set forth by Congress and the relevant statute, in this case, the Natural Gas Act. So what was happening here was that under the circumstances present, FERC's order didn't adequately explain why it determined there was need for the project. It wasn't a situation where the court said there was no need or that the process was wrong. It just couldn't verify. It couldn't see the work that was done. And as Erin mentioned, those circumstances are pretty unusual, and that's why we think it's going to have limited effect. If you look at certificates that were issued this year, there's at least 9 of them, all of them were supported by precedent agreements with non-affiliated entities. So you have negotiations between 2 commercial parties, arm's length, no evidence of self-dealing there, for 100% or nearly 100% of the proposed project's capacity. That is more typical of what we're seeing and why I think there's going to be somewhat limited effect of the Spire decision going forward.
Thanks, Chris. That was helpful. So now in talking about what implications this Spire decision will have on future FERC pipeline approvals, Morgan, if you could describe the new draft FERC policy statements that I mentioned and how that potential impact shakes out on, landowners, climate, and environmental justice considerations.
Yeah, so happy to touch on that. I think, we've done a pretty sufficient job in this conversation already. Sort of outlined some of the policy statement changes on project need. I will note that is an area that has been raised of concern, the reliance solely on precedent agreements as a demonstration of need for a while now. But just to give some more broad context on how the new policy statements came to be and the calls to, refresh, renew the 1909 policy statement with more modern flavor. So in 2018, under then FERC Chair Kevin McIntyre, the FERC began considering the idea of charting a new course for its 1999 policy statement and at least getting public feedback on what a revised statement could look like or what changes folks had been asking for, and opened up a public comment period on that. Thousands of commenters of many different backgrounds, from the industry to NGOs to individual community members, academics, public officials, what have you, proposed an array of policy changes. One key issue that did come up, as I said, was this precedent agreement issue as demonstration of need. But among others were some other areas where the policy statement had either been silent or in application folks felt that it was time to have those issues, fleshed out in the policy statement context. So following longstanding calls for reform and noting areas where the commission had been chided from courts and others for falling short of duties under the NGA, in mid-February 2022, in its open meeting, the commission released 2 policy statements, one updated pipeline policy statement and one interim GHG policy statement. As with all policy statements, they're non-binding but offer a strong indicator of how the commission's NGA reviews will go. And as released, were applicable to project reviews from the February opening meeting onward, but I'll give some history about what happened sometime after that. So some key areas of where the pipeline policy statement in particular represented changes from the 99 framework were among project need, which we've discussed, environmental justice, environmental impacts, and impacts on landowners. So on environmental justice, the commission, presumably attempting to right some past bad analyses, look at Atlantic Coast, Rio Grande, and some areas where, courts or the public had noted they'd given short shrift to environmental justice concerns. The commission noted that it would attempt to more appropriately scope geographic areas that it selects for analysis consistent with best practices and federal guidance. It also noted that mitigation options should be tailored to the needs and harms a community might face, which would require close consultation between project developers, the community, and the commission, and noted, of course, that's all subject to ex parte rules. On environmental impacts, the commission noted that environmental impacts would be considered along with all other impacts as part of the commission's public interest determined under NGA. I don't think that's a major surprise for most folks. And on landowner impacts, commission noted that it would consider a wider range of impacts to landowners, and in doing that, it'd be considering landowner impacts based on ideally robust early engagement with interested landowners, continual evaluation of input from those landowners throughout the proceeding, and that the commission would consider what a pipeline applicant had already done to acquire land through good faith negotiation, or an applicant's plan to minimize the use of eminent domain upon receiving FERC certificate. I will note for the second policy, that was the more controversially received of the two policy statements, was the interim GHG policy statement, in which the commission, again, noting it had been chided by courts in the past for not adequately considering climate change impacts or making significant determination for GHG emissions, established a rebuttable presumption that proposed projects with 100,000 metric tons of CO2 emissions will be deemed to have a significant impact on climate change, thereby triggering the preparation of an environmental impact statement rather than the more slimmed down EA. FERC also said it would consider a project's reasonably foreseeable GHG emissions that have a reasonably close causal relationship to the project, which could include upstream and or downstream GHG emissions for certain projects, in addition to direct GHG emissions resulting from the construction and operation of the project. And FERC also, lastly, I will say, said that it could condition the approval of a project on the sponsor's mitigation of the project's climate change impact. And so to kind of touch on the reception of those policy statements, following the rollout of the updated pipeline policy and interim GHG policy, an array, of voices shared and an array of opinions. So for landowners, impact communities, to climate voices, folks who have been asking to see greater transparency or closer compliance with some court rulings from a climate perspective, this represents a significant step forward towards balance, not necessarily a silver bullet, but the commission also faced rather significant opposition from industry voices. Significant comments came into the policy statement dockets, as Chris described, right? INGAA wrote comments, many other folks wrote comments, we wrote comments. But the commission also faced criticism, not just in the docket, but also in other spaces. There was a hearing in the SCNR committee in early March. And so the commission, acknowledging the industry's expressed desire for greater input, and also, acknowledging the other calls to slow walk the policy statements, the commission placed both policy statements fully on draft status, and open a comment period and reply comment period. And since the close of that comment period, that is where they remain fully on that draft status at this time.
Thank you, Morgan. I think that's a really helpful overview of the new draft policy statements. I think making sure that we have enough time for people to ask questions, I kind of want to move right into, what do we think that the future is going to hold at FERC? What are pipeline approvals going to look like moving forward? And I'm glad that Morgan mentioned the political implications of these new policy statements, and I was wondering if anyone wanted to talk a little bit about that. Chris?
Sure. Like we were joking before, that's sort of the $1 billion question. So at the moment, we don't really know what's going to happen going forward, and it's created a lot of regulatory uncertainty for the industry. These are capital-intensive projects. They cost a lot of money and take a lot of years to build. And so it used to be, over the 20-plus years that the 99 policy statement came into effect and FERC applied it, that as an industry, we would know this is generally what FERC is going to expect to see in an application, and we generally can expect an answer within 18 to 24 months as to whether we're going to be able to go forward. And that allowed the development that unlocked those benefits that I mentioned at the beginning. Right now, it's very uncertain. FERC has made the policy statements draft and has committed not to apply them to applications that are pending at the time it issues whatever final statement comes out. But that's difficult for projects that have a long lead time for development. And so I think what you're going to see is it's a stifling of the industry and a stifling of pipeline development. In terms of what the final product is going to look like, I think it's difficult to tell on some of the major issues like greenhouse gas and climate change. There's a pretty strong split among the commission between it's pretty much spearheaded by Glick and Danley. They're the ones arguing at all the open meetings. But as to whether FERC even has the legal authority to consider things like indirect greenhouse gas emissions, there are areas of agreement. I think if you look at the now draft policy statements and statements by Commissioner Christie, there's probably at least 4 commissioners right now who think there needs to be greater scrutiny of affiliate precedent agreements when determining project need. The DC Circuit has continued to affirm FERC's reliance on precedent agreements and even putting affiliate agreements on the same level as unaffiliated precedent agreements. But there might be, because there is bipartisan support for that, changes in that area. So it's a little difficult to tell. I think some of the lower hanging fruit issues like environmental justice and landowner concerns, the direct effects of a pipeline, there might be a path forward. But I think at least with some of the climate change issues, some of these broader questions of FERC's legal authority, I have a difficult time seeing what the path forward is going to be.
Erin, do you have anything to add on that?
I have something to add on a different topic, so I don't want to.
Morgan, do you want to chime in on what Chris just said?
Yeah, I can chime in on something as well. I think the politics around it, of course, is, as Chris says, the $1 million question, right? I think lots of folks are interested in where this could go, what future iterations of the commission would want to prioritize, like areas of these pipeline policy statements or the GHG policy statement that the commission could move forward with. I do think it's important, to note that it's not just the industry that's looking for that regulatory certainty, right? It's landowners, communities, climate advocates, environmental justice communities in particular, that really want to make sure that when the commission is moving forward with its project reviews, that it's doing it in a way that is compliant with the law, transparent, asks the right questions of applicants, ensures that it has the information that it needs to move forward with a fully informed decision. And so I think, there are areas of the proposed pipeline policy statement that, moving backwards from, what was proposed in them would represent, a major step backwards in terms of bringing regulatory certainty for those folks. And also, just thinking about the resource intensity that it takes for, folks who are advocating for the commission to get it right in terms of environmental justice and not, having a repeat Atlantic Coast situation where it's not scoping its environmental justice reviews adequately, or from the climate perspective, right? Every time the commission fails to do its significance determinations that it has to do, that represents resources and time for project, challengers and folks who are wanting the commission to get it right, but most importantly for, community members and folks who are impacted by this infrastructure.
Great, thanks, Morgan. Erin, you had something to add on a different topic?
Yeah, thanks. Chris mentioned the temporary emergency certificate, and I did want to make sure I addressed that. After the DC Circuit issued its decision that vacated the certificate for the Spire STL pipeline, with the certificate being vacated without a certificate of public convenience and necessity from FERC, a pipeline is not authorized to operate under the Natural Gas Act. And so Spire did file an application, and FERC issued a temporary emergency certificate that remains in effect right now that enables the pipeline to continue operating. And I did just want to emphasize that EDF has not called for the pipeline to be shut down. We express support for the continued operation of the pipeline and to ensure that the people of the St. Louis region have continued access to the gas and the fuel they need to heat their homes during the winter season. And I raise that, and I take this case extremely seriously, just to point out that, in public statements, Spire distributed communications to its customers implying that EDF was seeking to cut off their access to gas, and that is not something that we have done. And we continue to support, the continued operation of the pipeline while FERC resolves what the future of the Spire STL pipeline will be, which we think is really important that be done. Morgan just mentioned transparency, and that really needs to be done in a transparent and open process. Thanks.
All right, thanks, Erin. Very quickly, before we get to questions, I was hoping that each of you could maybe give a very, very quick overview of what people should be looking for in the future. So what people should be keeping their eye on in this process.
Sure. Like I said, I think there are certain areas where you're going to see some agreement and possible movement. So, FERC has appointed a new Counsel for Environmental Justice, not new so much anymore, but Montina Cole, I think she's been there for about a year plus. And they've also taken other efforts to broaden their outreach to community and facilitate public participation, like the Office of Public Participation. So landowner concerns and EJ concerns, I think, are areas where FERC might be likely to move. Same thing with, like I mentioned, affiliate precedent agreements. When we get to issues like climate change and indirect greenhouse gas emissions, like I said, there's sort of a fundamental legal difference of opinion how the commissioners are interpreting cases, and I think that's going to be trickier to resolve. So one thing to keep an eye out, the Supreme Court issued a decision this past term called West Virginia v. EPA, in which they discussed something called the major questions doctrine. I mentioned the APA is sort of the homework statute. This is sort of the stay in your lane statute, or stay in your lane doctrine, I should say. It was sort of a message to agencies to make sure that your actions are consistent with the authority granted to you by Congress. I think as courts continue to process that decision and apply it, that may shed some light onto whether and to what extent FERC can take some of the actions in the draft policy statements with respect to it, specifically indirect greenhouse gas emissions. Those are emissions not from the pipeline, but from downstream end users or upstream producers.
Erin?
Yeah, I think Morgan has touched with more specificity on some of the shifts that we see in terms of the certificate policy statement at FERC. So I'll just say, very broadly, I think, what EDF has described in comments and what we're hoping to see is that finalization of really a more comprehensive, transparent, open process that more carefully assesses whether or not new interstate pipeline infrastructure is needed, and also that really takes into account concerns on the ground, environmental community impacts. There was one other thing I wanted to mention, and I think now it's slipping my mind, so I might pause there. Thanks.
All right, and Morgan, any last thoughts?
Yeah, I think kind of a closing thought that I've got is that, we really need to think about the connections to pipeline safety and pipeline overbuild, and ensuring that, we have, that the commission, when it's making its decisions, are doing so in a reasoned way. But, I think that's like a common thread of the discussions that we've been having, is thinking about how we're managing, hopefully increasing, but limited, resources and time, and ensuring that, the pipeline infrastructure that comes online is pipeline infrastructure that is needed, consistent with the Natural Gas Act. Another area I think that, we'll certainly be watching is, how the commission will be able to, move forward and resolve, how it treats and analyzes greenhouse gas and climate-related impacts, so separately and differently than other foreseeable and indirect environmental impacts. Is certainly something of interest, to us. And so, as Chris said, those are the more controversial areas of it. It has been good to see, areas where advocates and the industry and the commission and all interested stakeholders have kind of, moved forward and evolved our collective thinking about environmental justice and landowner impacts. But certainly everything we do operates under a framework that needs to be adhered to. And so thinking about the ways the commission will do that going forward will certainly be interesting given the political time that we're in.
Great. Thank you so much to all the panelists. I think it was a very interesting discussion, and we will open it up if anyone has any questions. And James will grab you the mic so that Morgan can hear you online.
Okay, Travis Hallam, Pipeline Authority for the 3 affiliated tribes. Mine's just more of a statement and a request. So in my position on the Fort Berthold Indian Reservation, which is in the heart of the Bakken, I also have been fortunate enough to have dialogue with upstream developers who have reached out to me. And while prudent, it's not simplistic. I asked for the safest means possible. I basically do the job of FERC, BLM, Corps of Engineers for you. So I do not allow for trenching into Lake Sakakawea. I don't allow for trenching in extreme volatile terrain. And groups like WBI, Kinder Morgan have been excellent in meeting my request. But the approval process on your group, not FERC in itself, but you need to get with the Corps of Engineers and these other groups and put them in a position of success to succeed in their projects. We know in April and May that we're approving this, but we're not giving them the permits to make these connections on these long HDD bores until after the frost has come in. And you're talking, really, really, dangerous conditions. Human nature, when it's 30 below zero, you don't want to be out there in the field when you can be approving this and letting these guys build this in August when you have perfect conditions. So my request is use common sense. When you approve this, put them in a position of success, not risk. And that's what I've seen time and time again on the federal side. And it's like, we need to help them develop better, not put them in a position of danger. But that was it.
No, that's a great point about some of the delays we're seeing. And I will say, I think one thing we are seeing as an industry, this goes back to the Show Your Work statute, is that we have federal regulators, not just FERC, asking some more probing questions in response to these court decisions, not necessarily changing their process, but making sure they're better able to explain how they reached their decision. And I am hopeful that going forward, it reduces some of that delay, some of that uncertainty, and allows for a more timely construction, more predictable construction schedule.
Well, it's just not prioritized. So it sits on the desk for 5 months and then gets approved. It just needs to be prioritized.
I could certainly agree with that.
Next question.
So out of left field, I love this. We have attorneys up here. Usually I'm the one getting grilled by attorneys. So I love this turnabout. So y'all have talked primarily about gas pipelines. And I believe that you were talking about a liquid pipeline, correct?
I'm talking about gas.
You were talking about gas?
Gas capture. And
Okay.
gas capture is a benefit for us to reduce flaring. So
Okay.
we are supportive of responsible development.
I think that's important to hear. Could you, for the people on the what you just said?
We deal with a huge problem with gas capture and flaring, and these natural gas lines, in one manner or another, reduce that, that imprint from the natural gas flaring. So that's another reason why we're supportive. Even though it's not within our boundaries, we have that dialogue, build it to the best means possible, and we'll support it. And that's why we want that done in the state of North Dakota, because our flaring issues are ridiculous.
Thank you.
Can I actually comment on that real quick before you ask your question, Linda? I appreciate that comment and just want to note on that EPA's oil and gas methane rule, which does seek to limit flaring and improve some of those practices, is likely to result in enhanced construction or increased construction of gas gathering lines. And I think that's a really important dynamic to be keeping in mind, as we think about the PHMSA side of things, because those steps that may lead to build out of gas gathering lines just makes it all the more important for PHMSA to be thinking about its oversight of those pipelines, which is something that I know it's been thinking about a lot and has taken really significant action on in the last year. But just sort of keeping that eye to the future, that infrastructure is likely to continue to increase in the coming years.
Last question.
Oh.
Somewhat quickly.
Okay, thank you, Erin. Of note, you see up on a lot of presentations, we regulate 2.8 million miles. That's not true any longer. As of this year, it's now 3.4. So we've just increased our regulatory oversight of those type of lines by 600,000 miles. That's a lot to oversee, mostly overseen by the states. But my question, out of left field, we've been talking, we all know that FERC regulates or has siting and approval authority for natural gas transmission lines, right? No one currently in the federal government regulates hazardous liquid lines for cross-country lines, right? There were congressional hearings a year ago where there was a discussion of whether to give FERC that authority to do siting for hazardous liquid lines. Are any of you aware of any discussions after those congressional hearings about, I'm talking specifically about FERC, a proposal for FERC to have siting authority for hazardous liquid lines?
I am not. I would say the only conversations I'm really familiar with in terms of expanding FERC's jurisdiction right now is whether it should be tackling hydrogen. And I have not really heard much conversation about hazardous liquids. It doesn't mean it's not happening. I'm just not aware of it.
Same, yeah.
Same here.
Something to keep an eye out for.
Yeah.
All right. Well, thank you, everyone. Thank you for your questions, and thank you to the panelists.
Thanks all.